In this video I want to deal with this question of vulture funds, so-called vulture funds, debt service providers, debt servicing agencies or companies like Pepper, like Mars Capital, like other companies who have bought debts from Irish lenders since the property crash in 2008, and they have then bought the mortgages, bought the charges, repossessed property, sold them, etc. Every time I make a video about a repossession property being sold at a BidX1 auction or anywhere else for that matter, invariably there's a certain small group of individuals who pop up and make comments that what Pepper are doing is unlawful or is not permissible or is against the law or they can't do that or whatever, and that sort of thing. And these people, for whatever reason, whether it's for personal gain, personal aggrandizement, personal, as I say, providing unqualified legal advisor services to other individuals, whether they want to be mischievous, whether they want to genuinely mislead, or whether they genuinely believe it, I'm not sure. What I can say though is that there's absolutely no difficulty with a bank, be it Ulster Bank, be it the Bank of Scotland, be it Permanent TSB, Irish Bank of Ireland, AIB, or any other bank selling their loan to the likes of Pepper or Mars or whoever, and then Pepper or Mars or any company like that being entitled to enforce the mortgage, enforce the charge if the money wasn't repaid, get possession and sell the property and give good title to the purchaser. That is happening every day of the week, quite frankly, in Ireland for the last number of years, and I and other solicitors deal with these properties all the time. Bottom line is, properties are bought at BidX1 auctions or other online auctions, and in due course the new owner is registered as the owner with the land registry. Land registry are the state body essentially, and your title then is guaranteed by the state. Every time though I make a video about such a property, you have people popping up, these lads and lassies, especially fellas, popping up and making these ridiculous assertions that they are not entitled to sell the property, they're not entitled to repossess it, etc., etc. And I want to have a look at this case here, a recent case involving Pepper. Here's the High Court case. This decision is delivered on the 22nd of January 2025. It involves Pepper Finance and Declan Egan. I've highlighted it because I think it's useful to highlight and show the Now I've highlighted the relevant parts of this case. This is the High Court decision from 22nd of January 2025. It's involving Pepper Finance Corporation and Declan Egan. You'll see that it is an appeal from the order of the Circuit Court from December 2023, which granted possession of the premises at Auburn, Old Dublin Road, Stillorgan in County Dublin to the plaintiff. The plaintiff is Pepper Finance. You'll see in January 2005 the defendant and his late wife, so Mr. Egan, Declan Egan and his late wife, provided a mortgage in favour of Bank of Scotland Ireland Limited in consideration of a loan of 1.2 million for 15 years. The mortgage later fell into arrears. So this is a straightforward loan. The Egans gave a mortgage on their property, and a mortgage is essentially a mortgage or a charge, a security on the property. The mortgage fell into arrears. In May then, you'll see in 2018 and 17th of May, the plaintiff, that's Pepper, entered a mortgage sale deal with Bank of Scotland. And on the 28th of September 2018, the plaintiff entered a deed of conveyance and assignment which assigned to the plaintiff all of the bank's right, title, estate, interest, benefit and obligation, both present and future, in the properties and the mortgages. And also you'll see there the right to demand, sue for, receive or recover, receive and give receipts for all principal monies payable, etc. So the Egans borrowed money from Bank of Scotland. Bank of Scotland sold the loan to, or sold the mortgage to Pepper. Paragraph 5. Whilst the deed was registered in the Registry of Deeds on the 23rd of October 2018, the plaintiff, that's Pepper, does not rely on that entry, but rather relies on the terms of the deed, whereby it says Bank of Scotland transferred the defendant's loan mortgage agreement to it. So Bank of Scotland basically sold their loan to Pepper, and that's what Pepper have been relying on in this case. The defendant's defence then, Mr. Egan's defence, is that the plaintiff cannot seek an order for possession as it is the legal and not the beneficial owner of the mortgage. In other words, he's making this argument that because Pepper only bought the legal mortgage and not the beneficial, is not the beneficial owner of the mortgage, Pepper is not entitled to get the money or repossess. In subsequent oral submissions, Mr. Egan claimed that the plaintiff lacked locus standi as it was not a retail credit firm, albeit that allegation was not addressed on affidavit. A Central Bank of Ireland document was furnished by the plaintiff which confirmed that the plaintiff was authorised by the Central Bank as a retail credit firm on the 27th of October 2016. Paragraph 7 then, you'll see there the defendant, Mr. Egan, argued that these proceedings should be referred for plenary hearing and joined with other plenary proceedings he issued shortly after the institution of the within possession proceedings. However, there is no basis for referring this matter to a plenary hearing, that is the finding of the High Court. And paragraph 9, it says the mortgage sale deed of May 2018 and the deed of conveyance and assignment of September 2018 transferred the defendant's mortgage and underlying debt from Bank of Scotland to the plaintiff being Pepper. The plaintiff is not, as claimed by the defendant, a third party without a horse in the race, is the legal owner of the mortgage loan agreement, and that gives it rights, including the right to seek possession where the mortgage has fallen into arrears and the other proofs have been complied with. The plaintiff seeks possession on its own behalf as the legal owner of the mortgage. It is not purporting to act on behalf of anyone else. Paragraph 11. The Supreme Court recognised in SP v. OSUS versus HSBC International Trust Services that the assignment of a debt is lawful. This is absolutely key, and the next time you have one of these unqualified legal advisors telling you that Pepper can't repossess or can't enforce a mortgage that they bought from somebody else, it is absolute nonsense. Here's another of these decisions. Paragraph 12. The essence of the defendant's argument appears to be that a mortgage may only be enforced by a party which is beneficial ownership of the mortgagee's interest. Arguments along these lines have been rejected in a number of judgments. Paragraph 13. In Carney versus KBC Bank, the plaintiff's loan facilities and or mortgages had been sold or securitised. The plaintiff contended that the defendant bank therefore had no right to enforce the loan. This was flatly rejected by Birmingham J in his decision to strike out the proceedings as frivolous and vexatious. He stated, amongst other things, but there's another obstacle which faces the applicant and which he has not addressed, and it is that there is nothing unusual or mysterious about a securitisation scheme. It happens all the time so that a bank can give itself added liquidity. It is typical of such securitisation schemes that the original lender will retain under the scheme, by agreement with the transferee, the obligation to enforce the security and account to the transferee in due course upon recovery from the mortgagors. Number 14, paragraph 14, a similar legal title to the mortgage was held by the plaintiff in Pepper Finance versus Jenkins, a 2018 decision. The defendant argued that the beneficial owner of the defendant's loan or related security had to be involved in the proceedings so that the defendant could know with certainty the identity of the parties entitled to receive repayment of the loan, and that was held not to be the case. More recently, paragraph 15, you'll see a similar argument was trenchantly rejected by Simons J in Start versus Kavanagh. With respect, both the case law and the legislation make it clear that the holder of the legal title to a credit agreement is entitled to enforce same. In other words, if Pepper or Mars or somebody buys the loan, the mortgage, the charge from any lender who has originally lent the money and the mortgage has fallen into arrears, then Pepper or whoever, the legal owner of the charge, can enforce the charge and repossess the property. The defendant sought to rely on authorities, all of which relate to different shortcomings in the proofs that are relied on by the financial institution seeking possession of a mortgage property. In other words, the defendant was relying on various cases where the bank, the likes of Pepper or whoever, had failed to get possession, but the reason for that was because there was different shortcomings in their proofs, and once they rectified those proofs, they were then entitled to get possession. The conclusion: the defendant did not dispute the fact of the arrears on the mortgage as had been set out on affidavit, and his case was principally based on what he said was the plaintiff's lack of locus standi to enforce the mortgage where a different entity is the beneficial owner thereof. For the reasons set out above, I have found that the argument to have no basis in law. The plaintiff has satisfied the proofs necessary for an order for possession, and that is it. Pepper were granted possession of an order for possession of the property. I can't put it any stronger than that. There's another decision, January 2025. It's only a couple of months old, and that is the position. There's absolutely nothing wrong with a bank selling its loan, selling its mortgage, selling its charge to the likes of Pepper or Mars or anybody else, and they in turn then, as the purchasers of the loan, can enforce it. By the way, I'll put a link to that particular decision in the YouTube comments, or not the comments, the description box underneath the video on YouTube. I'll put a link to that video, or to that decision of Miss Justice Marguerite Vulture, Pepper versus Egan.